Hello dear students, I am Dr. Brinpreet and now I'll be talking to you about the economic theory of property part 1. Now first let us introduce the topic. Property law is a unique aspect of the study of law and economics because it deals with the legal framework meant for allocating resources and distributing wealth among people and communities. Amongst the different thinkers of property law, William Blackstone believed that property is a means of providing its owner with complete control over the resources, and that is why he regarded this power to control the resources as the guardian of every other right. On the other hand, Max Gluckman, who studied the concept of property in relation to the African tribes, held that the property right only accorded its owner a responsibility and not freedom, because the owners of property are the rich people who were responsible for contributing to the prosperity and growth of the other people in their tribes. In contrast to this, the communist thinkers like Karl Marx and Friedrich Engels consider property as a means by which the few resourceful people only indulged in dominating over and enslaving the weaker and less resourceful people. The concept of property and property rights is interdisciplinary in nature, which is why it generates potential confusion among various scholars. The term property right connotes two different meanings from the point of view of economics. One approach establishes property rights as the ability to enjoy a piece of property, whereas the other approach, which is more popular and rather old, explains property rights as the state assigned rights to a person. The former criteria to define property rights can be termed as an economic right, whereas the latter can be characterized as a legal right. Economic rights are thus the ends, while legal rights are the means to achieve those ends. The problem with economic rights is that the economic rights that people possess over various assets are not constant. Rather, they are a function of the people's own efforts to protect their resources from the potential attempts that other people might make to capture these resources. In contrast, legal rights are the rights that are recognized and enforced by the government. These rights rather enhance the economic rights of a person. Now, we first discuss the meaning of property and property rights. The concept of property, as explained in economics, defines property as the resource or estate that a person can own or transfer to another. Property rights as a concept is a basic precondition for a capitalistic economic system to evolve and influence the social and economic behavior of the people of the country. Classical thinkers of economics such as John Stuart Mill, David Ricardo and Adam Smith believe and view that private property is a resource that creates an environment where maximum productivity can be created based on profit motives. From a legal point of view, property is said to be a bundle of rights that describes what people may or may not do with the resources that they own, that is, they may use, develop, consume, sell, destroy, donate or even exclude others from the use of that resource. These rights, however, are not immutable because they may change from one generation to another. But at any point in time, the concept of property entails three fundamental features. One is that these rights are impersonal, meaning that they are attached to property and not people. Only the owner of the property has a right to it. Secondly, the owner has the freedom to exercise his right over his property, which means that the law can neither forbid nor require him to exercise his right over the property. Thirdly, the law forbids other people from interfering with the owner's autonomy to exercise his right over his property. Now, in the event that the person interferes with the property rights of another, the court will issue orders against him and prevent him from interfering with the rights enjoyed by the person over his property. Property is thus a concept that creates a zone of privacy in which the owners can exercise their discretion over their resources without being accountable to others. This also means to say that property gives the owner liberty over the things. The theory related to property rights renders economic choices or behaviors legitimate from a legal point of view and thus defines property rights as a pattern in which the resources are allocated in a society. From the point of view of economic analysis, property rights help to determine whether the system of allocation of rights in a society is economically efficient or not. Although assigning private rights to property does not in any context imply that it is a means to attain maximum social welfare. Property rights are thus a complex phenomena, and the complex nature of the concept of property rights is what makes it dynamic. Property rights, therefore, are not absolute rights because they can even be changed by the actions of other individuals. Having said this, now let us move to discuss the theories of property. There are various theories that explain the concept of property. The traditional legal point of view on property law is regarded as weak in its application, especially from the point of view of the law of contracts and the law of torts. That is why the students of law believe that the common law of property is diffused and unorganized. Under such circumstances, economic analysis can be used to bring out more coherent definitions for the concept of property. Some of the theories that have been discussed here to explain property rights are the labor theory, the occupation theory, and the economic theory of property. Let's first discuss the labor theory. John Locke was one of the most prominent and influential thinkers in the field of property rights. According to Locke, a man is the owner of his own self, and as a result, he is also the owner of everything that he produces. The labor theory given by John Locke explains that a person completely owns whatever he produces out of his own efforts. This ideology is based on the idea that a society should encourage labor and that property or resources must be distributed according to individual productivity. The basis of the theory is the approach which states that all property was originally a common asset, but people belonging to a particular place had the right to acquire a share of this property by virtue of putting in their labor. Locke here outlines his labor theory of property acquisition, which differs significantly from the prevalent theories of divine right, royal patronage, and conventionally constrained access to common property. It endeavors to defend the creation of private property outside of social context, that is, without the consent of neighbors or peers and the state control. Many of the same justifications have been used today to support the resistance of current private property owners and public property users against the government interference in their ownership rights. The commons are a real resource of common property in Locke's natural state. The state of nature is used and regulated to accomplish a certain set of aims by adhering to certain laws assigning rights and obligations. It is neither a lawless wilderness nor an open access free for all. The creation of new private rights would be restricted by the labor theory on the basis of justice. As scarcity grows, utilitarians who base their arguments on efficiency will support the growth of private rights. By taking existence values, other non-use values and biocentric values into consideration, utilitarian analysis may also support the labor theory's emphasis on anthropocentric rights. If, like Locke and his contemporaries, one believes that human work is the manifestation of God's purpose on earth and that humankind is fashioned in God's image, then Locke's claim that labor establishes property rights makes sense. The labor theory of acquisition reduces to first occupancy property purchase in the absence of this religious sentiment. Now we discuss the occupation theory next. Jean-Jacques Rousseau, the most renowned French philosopher, developed a theory of property based on initial occupancy supported by work. According to him, unequal distribution results from human differences in ability and the initial appropriation is acknowledged by both the parties. While Rousseau deviates from the Englishman by assuming that scarcity and unequal distribution will lead to disputes, this is generally consistent with Locke's beliefs. According to this notion, the owner of the property was the one who discovered it first and had the right to dispose of the asset. As long as the person in possession can hold on to the resource until someone else establishes a better entitlement, this approach offers stability and security. The law of property reflects this viewpoint. If someone holds on to land for a long time, the original owner may not be able to challenge the possessory title. The idea of adverse possession of land serves as the foundation for this. In certain situations, an outsider may be recognized as the legal owner of land if they have been squatting there for a long time and the genuine owner has not removed them from the area. The people came to an agreement on a social contract which governs appropriation and could put an end to this Hobbesian free-for-all model. Rousseau is therefore more concerned with the fact that the person perceives exclusion on the property as more important as compared to the information about the ownership of any asset. Since exclusion cannot possibly be secured in the natural world, the French philosopher ultimately created the concept of a powerful state that grants ownership rights to a community over individual rights and makes the state the sole owner of those powers. Now we discuss the economic theory of property. The economic theory of property rights explains the possibility of economic activity being regulated through markets. In such a situation, the government does not need to interfere and the outcome of the market process is considered to be efficient. The concept of property raises four fundamental questions when it comes into contact with property law, and these questions are: number one, how are ownership rights established? Second, what can privately be owned? Third, what can the owner do with the property? And fourth, what are the remedies for a violation of the property rights? Bargaining theory is a more general theory that can apply to the problems and concerns of a civil society and even to explaining property and property rights. In the bargaining theory approach, people often agree on the terms and conditions for interacting and cooperating with each other, but sometimes these terms and conditions may be influenced by external factors like law. The bargaining theory explains that the terms on which people agree among themselves are usually more efficient than the terms imposed on them by legislation. Therefore, in such situations where bargaining can succeed, the law is deemed unnecessary and undesirable. But when bargaining fails, the law becomes a necessary instrument to ensure that the people cooperate amongst each other. The bargaining theory explains that cooperation between the participants can lead to the generation of a surplus that can benefit everyone. All these ideas can be used to answer the four questions related to property rights that have been pointed out earlier. In certain circumstances, the use of property law is not essential to answering these questions. Rather, it is private bargaining that helps to understand what is property, who has the right over the property, what a person can do or not do with this property, and who all can interfere with the owner's property. How much a law can regulate property rights is very efficiently explained with the help of the cause theorem. We discuss now the cause theorem. To understand how the cause theorem works in the case of property rights, we take the example of a cattle rancher who lives adjacent to a farmer. The farmer grows crops on a part of his land and leaves a part of it uncultivated. The rancher allows his cattle to move all across the land. The rancher's and the farmer's land have clear boundaries, but there is no fencing on either of them, and that is why the rancher's cattle quite often wander into the farmer's land and damage his crops. Now, there can be alternative ways of reducing the damage to the crops, such as by building a fence, reducing the number of cattle, or supervising the cattle and not allowing them to move into the farmer's property. An efficient way of solving the problem is for the farmer and the rancher to bargain with each other to decide who should bear the cost of the damage. Otherwise, the liability for the damage can be conveniently assigned by the law. The two alternative legal remedies in this case can be One thing, the farmer must ensure that he keeps the cattle away from his property, and in case the cattle come in, he will himself be responsible for the damage. Second would be that the rancher must be held responsible for ensuring that the cattle stay on his property, and in case they move on to the farmer's boundary, the rancher should have to pay for the damage. Now, in the first remedy, the farmer will not have access to any legal recourse against the damages done by the rancher's cattle. So, the only way the farmer can protect his crops is by fencing his field. The principle of fairness under law requires that the injurer must pay for the damage caused to the farmer's property, but Ronald Coase devised a solution to this problem in terms of efficiency. Assuming that the invasion of the crops by the cattle causes the farmer to incur a loss of $100, the cost of constructing the fence around the farm is $50 and the cost of installing the fence around the ranch is $75. The principle of efficiency requires the farmer to build the fence around his field instead of the rancher having to build the fence. If, as per the law, the farmer is required to construct the fence, his cost of $50 for the fence will yield him a savings of $50, the $100 of the loss of crops minus $50 for the construction of the fence. But if the rancher has to build the fence, he saves a net of $25, which is $100 of the loss for the crops minus the $75 meant for fencing. Clearly, the first remedy, which helps to save $50, is a more efficient way than the second one. The entire discussion makes it clear that the first remedy, where the two parties are able to bargain, is more efficient regardless of whether the law interferes or not. Thus, the rule of efficiency states that the property right should be allocated to a party that values it more. Now, we discuss the transaction cost element attached to the theorem. Bargaining, however, may be successful in certain situations and may fail under certain circumstances, but it must be noted that bargaining occurs only when the parties communicate. This communication between the parties is what yields the transaction costs. Transaction costs are the costs incurred in the process of exchange. An exchange occurs in three different steps. Number one, finding a partner with whom the exchange has to be carried out, reaching a bargain between the two transacting parties, and third, enforcing the bargain, that is monitoring the performance of the parties and putting a check in case of violation of the agreement. The transaction costs thus include the search cost, the bargaining cost and the enforcement cost. The bargaining theory assumes that the parties involved in exchange are aware of each other's threat value and the cooperative solution. The proponents of the game theory explain that if the information about the threat value and the cooperative solution is public and is known by the parties as common knowledge, then they can easily identify the terms to arrive at a cooperative solution. This also means that public information facilitates an agreement, but if the information about the threat value or the cooperative solution is private or not known by one of the parties, the bargaining and the negotiation process become complicated because private information impedes bargaining. Ronald Coase has emphasized that when transaction costs are zero, Private bargaining helps in ensuring an efficient use of the resources regardless of the legal assignment of the property rights. It is primarily private bargaining which can take care of all such issues as which resources can be owned, what the owners can do with the property, and who all can interfere with the property. The Coase theorem specifically determines the conditions under which property law becomes important. It explains that if transaction costs are high enough to prevent bargaining, the efficient use of resources depends upon how property rights are assigned by the law. Another important inference that can be drawn from this entire discussion is that the bargaining parties have a greater tendency to cooperate when they are fully aware of their rights. But if the information regarding the rights is less clear or ambiguous, there is a lesser likelihood of an agreement between them. The result of this observation is that property law must favor a criteria for determining ownership that is clear and simple, and that is why it is important for property law to define rights clearly and in a simple manner, because if the ownership rights are not clear, it will become a major deterrent in the way of cooperation between the transacting parties. This will lead to a huge wastage of the resources as well. So now I will like to conclude my topic. The concept of property is an important area that lies at the interface between law and economics. Different scholars perceive the concept of property and property rights from varied perspectives. That is why the concept of property has assumed an interdisciplinary nature. From the point of view of economics, property is defined as a resource or an asset that a person can own or transfer to someone else. Classical economics typically believes that property is the resource that can generate maximum productivity and establish profit motives. The legal approach to property, however, explains it as a concept that is based on the principle of exclusion and provides an entitlement by law. Different theories are used to explain the concept of property. The labor theory propounded by John Locke explains that property is the ownership right accorded to a person as a reward for his labor and productivity. The French philosopher Rousseau, however, defined property on the basis of initial occupancy and stated that if a person is able to hold on to a particular land for a long time, he can establish his ownership right over the property. Now, in contrast to these, the economic theory of property is based on the bargaining principle. The theory explains that if in matters related to property, the transacting parties are able to bargain with each other and negotiate, then they can reach a cooperative solution more efficiently and will not require law to establish any entitlement. In this regard, the Coase theorem helps to understand that transaction costs play a major role in deciding whether the outcome will be efficient or not. If the transaction cost involved in the bargaining process is zero, then private bargaining can be used to obtain an efficient outcome and establish property rights without the need for a law. If, however, the transaction costs are high, then bargaining will not be successful and property rights will have to be established only with the help of law. With this, we come to the end of today's lecture. Thank you very much.